Based in Larkspur, California, Stephen A. Nielsen is a U.S. registered patent attorney with many years of experience in patent procurement and in achieving favorable results in federal court in the field of intellectual property litigation. Mr. Nielsen is the past chairperson of the intellectual property section of the Marin County Bar Association. Mr. Nielsen received his JD in 1987 from Bolt Hall, University of California at Berkeley, and also holds a BA in computer science. He may be contacted at steve@nielsenpatents.com, on his website, nielsenpatents.com, or via his LinkedIn page.
Thank you, Robert, for that very kind and generous introduction. It seems to sound better year after year. As Robert mentioned, I'm Steve Nielsen. I'm a registered patent attorney. I work out of Marin County, which is in Northern California. If you Google Marin County patent attorney, my website comes up and I'm easy to find. And I always enjoy the emails and even the handwritten letters that I receive on these presentations. Today we're going to talk about diversity and inclusion, and we now have an added concept of equity, which seems to have entered into the mix of what I'm often called the movement, and it's often called DIE, and I've seen corporations, companies, and schools that have DIE officers. It's considered to be at the C level, and there are a lot of people who are as consultants, and some of the materials that I'm reading from today are from DIE consultants or officers in various schools and corporations. Just a few years ago, the term D&I was relatively new to society and is now in the categories of required CLE requirements in various states. And later on, we're going to talk about the states that do have required D&I or DIE requirements for CLE certification. In my past lectures, it's maybe my fourth or fifth year doing this, they've focused on definitions of the now well-known concepts of implicit bias and explicit bias. And such concepts are now well-known, and we don't need to rehash that, because I'm sure if you watch other presentations, they get a little dull going through that over and over. So what I want to do is focus about where are we now in just ending the first quarter of 2022 in diversity, inclusion, and equity, not only in the legal profession, but when I put this together, what I'm finding is there are crossovers into other areas of normal life, which is to be expected, because the world is not just divided between lawyers and non-lawyers. For example, later we're going to talk about certain schools requiring coaching in loan counseling as well, as far as D&I, and that's going to happen in some ABA law schools, which transcends the narrow concept of the legal business. The goals of this presentation are manyfold. My top three here are: how do we define progress in the movement? And what does it now mean that we're including the concept of equity? How does this correlate with the concept of social justice, restorative justice, fair housing, affordable housing, and now with gasoline prices? Just how does that reconcile with the movement and what's going on in society? We're going to talk about what's new in the movement, and there's been a plethora of great new articles on this. And then, are there any discernible trends in the movement? Are we seeing threads or commonality with what's happened over the year? Anything, any article that's of any note or of any interest was diligently found, gathered, and marshaled by Robert Roselle. He's the proprietor of this organization. He's an experienced attorney and CEO of CCE, and he's very patient with me in finding articles of note and presenting them to me in a way that sort of makes sense that I can put together for this presentation. We also want to talk about the current theories that aren't working in this subject. We have innovative and hopefully effective actions in diversity, in addition to what the large law firms are doing. They're often called big law. There's some good ideas which have percolated to the top that support attorneys in organizations in the D&I&E movement. And one of those theories we're going to talk about later is summer associates and first-year associates in the large law firms have never been more diverse, but the challenge is to nurture such young lawyers so that they can thrive to the top of a large firm, which is no easy trick for anyone, regardless of how qualified or socially connected. We have some great news here. We have Justice Jackson now on the Supreme Court. And the question is, how does this confirmation lie as far as success in the movement? Does it mean the movement's been effective, or is it the one outlier? Is it something that is indicative of a larger trend? And also, does the backlash from our president specifically looking for a justice from an underrepresented group hurt the movement? So we're going to have this tension, and we're going to see this later on in some of the slides coming up here about certain courts, certain jurisdictions rejecting quotas for CEOs of boards of directors. And is that going to be a backlash here as well? In one way, it doesn't really matter because Justice Jackson is appointed for life. So that is a done deal and a wonderful accomplishment for the movement. In some of the newer literature, the question is asked, can C-suite diversity officers really make a difference? And we have the new acronyms of Chief Diversity Officer. As I mentioned before, we might have Diversity, Inclusion, and Equity officers. I like CDO because it shows you're at the C level where a difference can be made. Many large firms are appointing Chief Diversity Officers. Of course, these people have other duties as well. They aren't the full-time diversity officer. It's probably another hat they wear as they're trying to bill their hours and feed their overhead. But the position does send a message about the importance of the issue to both the firm members and the public and the potential or current clients of the firm. Later in the slide, we'll talk about how the Coca-Cola Corporation requires firms to be of a certain diverse mix before they will get their business. And that hasn't been objected to because that's private enterprise making a decision. And there's been no real controversy on the Coca-Cola movement to hire only firms that are diverse. Interestingly, from the literature, the movement seems to be well received by busy law partners and are taking notice of the issues involved. We all know the overworked lawyer, small firm, big firm, solo, not even having time to get a new photograph taken of themselves, just crazy busy. And that bleeds into other lectures that I've done on competence and avoiding what I see as hot mess syndrome, something that happens to a lot of busy people, especially during our exceptionally busy times just coming out of the pandemic. Interesting things going on in Florida. So before we talked about the issue of quotas and making a composition of either a Supreme Court bench or a CLE presentation dependent or requiring a certain amount of diversity, Florida took a very interesting and to me surprising position that bans Florida lawyers from receiving CLE credit for programs that require diversity among panelists, including the American Bar Association's CLE programs. To me, this was stunning. I almost have to read it again. It bans Florida lawyers from receiving credit for programs that require diversity among the panelists. To me, that seems rather extreme. And I think that the free market economy should allow Florida lawyers or anybody else to buy a CLE program, consume it, and get the credit. This just makes no sense to me at all. What's interesting, the court stated that we reject the notion that quotas like these cause no harm. Quotas depart from the American ideal of treating people as unique individuals rather than members of groups. Quotas are based on and foster stereotypes, and quotas are divisive. I guess the issue isn't always also clear cut, and I guess in Florida there's room for reasonable minds to differ. But I think this is worth noting about, and as opposed to me talking about implicit versus explicit bias, what I'm finding more interesting here this year is where is the line? And here, Florida felt someone crossed over the line of requiring diversity in CLE panelists. So do other states have requirements for CLE panels? Do other states forbid their attorneys from getting credit where the panel has a quota? It'll be an interesting area. To my knowledge, Florida is the only state with such an interesting rule. And would other states agree with this decision? Well, we'll know more when we do this presentation again next year. My guess is no. I think Florida is an outlier and they're going to sit there. But I've been surprised before. We will see. On the issue of quotas, as reported by an article by Wilson Sonsini, one of my favorite law firms, the SEC approves a NASDAQ listing rules regarding board diversity. And the rule change, which has been adopted, requires a disclosure-based framework relating to board diversity. Under the new listing rules, NASDAQ-listed companies will require, subject to certain exceptions, to have or explain whether they do not have an applicable number of diverse directors, and they're required to disclose certain board-level diversity statistics on an annual basis. So here we have Florida and the SEC having radically different views. I'll be interested to see if this survives over the next year, and what's going to happen on board members who buy certain shares, sort of buy their way into a board by being a significant shareholder. Will they need to appoint someone else to represent their interests on a board? Because a lot of the large boards in private corporations, membership is a function of owning shares of the stock. So I didn't see any learning on this, but if anybody has any ideas, I would certainly welcome your emails on this subject and how's this going to be affected when you may have a majority shareholder who doesn't fit the diversity rubric. Does he have to hire a proxy? Who knows? There's a California law requiring board diversity that was struck down recently. So here again, the pendulum has shifted. In 2020, there was an assembly bill that became law signed by Newsom that requires publicly traded companies based in California to have board members from underrepresented communities, including people of several races and ethnic groups, and people who identify as gay, lesbian, bisexual, or transgender. When Gavin Newsom signed the bill, he proclaimed it a victory for racial justice and empowerment. Well, here's an article of April 3rd, 2022, in New York Times. that reports a group called Judicial Watch obtained a judgment finding that the law violated the state of California Constitution. Interestingly, this was done at the Superior Court level, at a Superior Court in Los Angeles. The opinion did not give a detailed reasoning, but stated that the law was, quote, a bit vague. And of course, an appeal is expected, and I look forward to reporting on this next year to see if it's upheld or not. And I'm interested as to the vagueness of it, how certain diverse categories are defined, and also will categories of diversity change over the years, because nothing is static in human evolution or in anthropology. Interestingly, LinkedIn has become ubiquitous in the business world. I think most people have a LinkedIn account and use it as a source of marketing. On my front page, my LinkedIn account is there, so you can read some of the things that I wrote, see links to my website, etc. So LinkedIn has become sort of an interesting and effective channel for change. And LinkedIn has debuted a new series of articles called Top Voices in Racial Equity. And there's a Carolyn Fairchild who's the editor. And they now have, I think it's rotating perhaps, 10 thought leaders writing articles on various subjects, such as gender equity, nuanced discrimination. Here's a term I just learned in the last few months, nuanced discrimination. I want to talk about that later, but that could be sort of the interesting cutting edge of where we're going in this field. Nuanced discrimination in the workplace, the high-tech equity gap, and someone's mentioned that the world of Bitcoin, digital currency, cryptocurrency is male dominated. And my quick response is, well, maybe that shows that other people are smart enough to not go in there. So just because there's a big field doesn't mean it's a great way to go. Reminding me of the tulip debacle in Holland. And no, I wasn't there. I just read about it. I'm not quite that old yet. And then we have the need to unlearn skin tone bias. Again, this is a somewhat nuanced discrimination. And LinkedIn is looking for contributors. So I would encourage everyone who has an interest in this to write articles and send them there. It's a great way to get published in this really interesting field. And this seems like a great and excellent forum to learn a broader approach and broader definitions to the movement. And what's interesting in including LinkedIn to a sort of a CLE for attorneys presentation is we get into the broader issues of society. And I sincerely believe that the law profession is just a microcosm or a reflection of society at large. So it seems rather myopic that we just look at, what's going on with large law firms, what's going on in the courts, but take a look at the movements in society and the workforce. And LinkedIn's a great way to go. And I would encourage everyone to read this this ongoing forum. The state bar of California is interesting. As part of the license renewal for this recent year, one of the questions asked, mandatory filling in of the blanks for allow one to pay their fees and practice law for another year, includes answering questions that include such categories as transgender and cis. Now, I hate to admit this, but I saw the choices there and I was clicking the buttons and I had to Google what the ones I didn't know, and I didn't know about cis. So I looked at it, I thought, yeah, close enough. So click that, but that's really interesting that it's a mandatory survey that lawyers have to click and figure out to get their license. So it's obvious the California State Bar is making some very concrete steps to address this issue. And they also have a 5-year plan as an objective to lead with diversity, equity, and inclusion, as core values across the organization. So what they're trying to do now is figure out, where is the body of members, where do they fit in as to the various categories or the current categories of diversity. And my best guess here, those categories are going to expand as the years go on. Another great resource that Robert Mazel found for me on this is a broader picture of bullying in the workplace as being related to diversity, equity, and inclusion. The theory being that those of diverse backgrounds might be more subjected to bullying than others. As a young associate in a law firm, there was I guess I could talk about it now, it's been a while, a partner who thought everyone was deaf and raised his voice often and used names that weren't good. Of course, this is the early 90s when the world was a bit different. And as I studied this article, that would be under the category of bullying. And at that time, this leader of the firm was an equal opportunity yeller and screamer. Those who know me know exactly what I'm talking about. But then the bigger picture is, which I never saw, was that bullying was inflicted more upon those of a diverse background. And many women have reported being subjected to workplace bullying. And also what's interesting about this article, it's really good. Let me just find the, where I was on this here, I'll find it in a second here. I'll add it to the slides at the end here, is that often bullying is seen as the omission of commissions or communications. And it's often seen as women being left out of important email communications. And to me, this sort of fits above to this category that I recently discovered called nuanced discrimination on here. So I can't imagine this happening in law firms, but maybe it does. But that's an interesting way to sort of broaden our view of making an improper discrimination by leaving certain people out of important email communications, and in the business world, an absence of commissions. Also, looking to the bigger picture of discrimination, diversity, equity, and inclusion. As I mentioned before, there's a recent article by Stephanie Francis Ward, published by, I believe, the ABA, February 14th, 2022. And then there's a proposal, which I believe has been passed before the ABA, to require loan counseling and cross-cultural competency programming for ABA accredited law schools. To me, the concept of cross-cultural competency sounds very intriguing. In the past, I've strived to treat everyone the same, and then this, to me, this idea is in juxtaposition with what we saw with the California Superior Court striking down the quotas for boards, saying it perpetuates stereotypes. So my question is, if one adjusts their method of communication or interaction based upon culture, does that carry on stereotypes or perpetuate stereotypes? I'd love to learn more about the concept of cross-cultural competency and how that relates to the actions one takes to honor people of different cultures without being condescending and without perpetuating stereotypes. So again, I'd welcome your email on that. What I also like here is that there's a movement here to require loan counseling also as part of the curriculum for ABA accredited law schools. I think loans have become sort of very important for everyone. It's difficult to buy a house at all, let alone without a loan. And that seems to be an important part of our society. And I'm glad that's permeating in the law schools and the practice of law, because it makes the law more meaningful and more approachable to non-lawyers, that this is being addressed. Also, what happened, or I found in March of this year, there's new training programs, something called Diverse Lawyers Trial Academy, which hosts a 2-day training for first chair trial roles. Well, first of all, I think it's wonderful that there are many trials are big enough where you'd have, first, second, third chair lawyers. Many lawyers who try cases are the first and only chair. So I think it's really interesting how this might be geared more toward big law, where you're going to have trials that justify the expense of 3 lawyers. But permeating down, what the article talks about is that first chair at trial appears to be an elusive position for women. And digging a little bit deeper into this article, into this trial academy, it seems to be twofold. One, I was surprised about. It provides modeling for diverse lawyers. And what was interesting and, I don't know, arguably insulting, I don't know, was that there's a theory that if part of the academy, the students see diverse lawyers putting on direct and cross and objections, authentication of evidence, opening, closing, all the things lawyers do in trial by diverse lawyers, providing modeling for such diverse lawyers. But to me, more importantly, the article talks about dealing with obstacles that diverse lawyers might directly be subjected to. One of those, I think I took the slide up for this year, was the fishing stories. Some judges will talk about fishing, and that's not to be done because not everybody fishes. So I guess there's 2 prongs to this Diverse Lawyers Trial Academy, but it's a great way to bring the issues to bear and to give tools to diverse people so they can be first chair. I don't know why they'd want to be, but that's another story, of a large trial. So this is definitely positive progress for the movement. So the stats are in for last summer's summer associates, and it was, quote, the most diverse ever measured in every way. This is from the ABA Journal, written in January by Deborah Klassen-Weiss. It's the biggest diversity gain in 29 years. So I think this is good evidence that progress is being made. In the prior years of me giving this presentation, I've never had anything so tangible to show progress is made. Of course, this is progress in a very narrow strata of big law. You've probably heard my views on big law. It's a wonderful place. It's great for big corporations. Many lawyers do well, have excellent careers at big law, but it's just a thin grain of lawyers who work at big law. And I don't think it's even a microcosm of the rest of the practice of law. But here it's a tangible gain. And then, as I mentioned before, the bigger issue is how does anyone do well at big law, and especially with the diversity issue. But again, there are mentors and programs going on at big law to address this issue, so that part of this greatest diversity gain in 29 years, hopefully in 7 years, we'll see that at the partnership level when these first year associates make partner. We'll know in 7 years. So again, the challenge is to develop and promote associates at big law over the years. And in my humble opinion, it's not a failure for someone to work at big law for 2, 3, 4 years and then do something else. It's a very difficult environment for anyone. We're also seeing a cultural shift starting in high schools that supports the movement. And of course, high school students eventually go to college, and then college to law school to the workforce. So it's starting to start more organically at a much younger age. California law now requires high school students to take ethnic study courses to graduate. California high schoolers will be introduced to concepts that are typically presented at the college level. And interestingly, this is already a graduation requirement at other California state-sponsored colleges. So this is great. Maybe high schoolers will get it 2 or 3 times. They get it, the studies in high school and then college and then law school. And I wonder if there's sort of going to be some anthropology classes or concepts in here to ingrain. I'd be interested to learn just what is the substance of ethnic studies at the high school level, and is it a sort of a global view or myopic as to what's going on in this country only. Look forward to finding that out. There's an article of just pretty recently that women are nowhere near closing the gender gap at the large firms. For some reason, COVID did not help matters, and women continue to be underrepresented. My wild guess here is that a lot of women find themselves to be the primary caregivers, and perhaps COVID made things a bit more difficult in that regard. I'm sure we'll see some studies coming out next year that might look at this just to figure out what happened and how it affected women and diverse people in the workforce. Hopefully we're all getting back to work. What I do like about this change in the work is it's now easier and more acceptable to work from home, which I think has a lot of great advantages for all involved. Something that's happening here is there's a community fund for Black Bar applicants. It's the links there, blackbarapplicantfund.com. Their mission is to fund bar exam applicants across the United States, approximately $500. The mission stems out of a desire to diversify the legal profession and raise the percentage of Black attorneys in the United States from 5% to 20% by 2024. So when we do this again in 2 more years, we'll check that number and see where they are. But there's a lot of grassroots help for this, and a payment of $500 may not seem like a lot, but I think every penny, every dollar helps. And it seems that education's gotten relatively more expensive, prohibitive. So I would encourage people to go to this website and support the movement from there. What's new for this year is Bloomberg now publishes a listing of law firms that meet certain diversity, inclusion, and perhaps equity standards. They publish a DEI framework or set of standards to be met for firms wishing to be listed. I believe they're still taking listings, and this hasn't been published yet. The benchmarks or standards include leadership and talent pipelines. And by talent pipeline, I imagine that goes to the summer associates and perhaps outreach programs to law schools and colleges to encourage diversity in training to go to law school, recruitment and retention, business innovation and strategy. To me, at the legal field, that would mean helping younger lawyers in their marketing efforts to become rainmakers, bias and harassment training. And I'd love to read that to see if they include the concept of nuanced discrimination, diverse brand. And for 2021, there are about 28 firms listed. So the listing is out, and the data for the 2022 listing is still being collected. So there's still time for other firms to become listed. I don't know what weight this has. My guess is maybe large corporations might look at this, sort of like the Coca-Cola company does. So this might be a listing well worth joining as a good marketing tool and also helping the firm internally look at these standards and develop programs to comport with the required standards. The Access Lux Center for Legal Education Excellence is a great organization. They're in the news quite often. The links are there on the PowerPoint. And what it does, it's a diversity pipeline initiative aimed at learning more about effective methods for increasing law school diversity by providing more than 1,200 aspiring lawyers with resources and guidance to pursue their goal of attending law school. The center is committed to understanding the barriers that impede access to law school for historically underrepresented groups and improving access to law school for all, identifying actual strategies and public policies to increase school affordability, and strengthening the value of a legal education. What's interesting is they've recently announced that 10 law schools have agreed to participate in the program to help minority and first-generation students gain admittance into law schools once they spend a year preparing for law school and working to improve their LSAT scores. So what does that mean in plain English? What it means to me is that the LSAT is a sticky wicket, difficult exam, arguably some cultural bias, etc. And the way I read this from my more in-depth research into this article and into their organization, students who take a year off, sort of a gap year, study hard for law school and improve are actually many of whom are giving funding for law school. And a lot of law schools have agreed to participate, either providing discounts to tuition or other ways to make this happen. So it's a wonderful movement. It's just kind of a raw deal. They got to spend a year preparing for law school and working to improve their LSAT scores. So that's interesting to me, but it's a great article, a great organization. What does the past literature tell us about what's happened here? It paints a dour picture. For example, this helps show the great progress we've made that we've just talked about in the prior 20 slides here. The pre-2020 information, the subject is bleak, not giving many coherent solutions. And this is, just 2 years ago. For example, the book Diversity in Practice by Cambridge Studies in Law describes that diversity in practice analyzes the disconnect between express commitments to diversity and practical achievements, revealing that often obscure systematic causes that drive persistent professional inequalities have been a real problem. And really, the past does not give an innovative solution. So that's why it's important to look to the present, see what's working, to ask questions. And I think what we're seeing now from the slides above, we're on that cutting edge of having quotas until they're rejected by courts. So it seems like the push has gone as far as it can, in some cases more than is sustainable, but at least the push is happening. Also, the past literature tells us that first generation lawyers have challenges. This makes sense to me. In law school, I would hear questions from students who were not from a family of lawyers, and those questions were different from those who grew up among lawyers. So to me, that is a challenge, just as it's a challenge for first generation college students to figure out college, the whole filling out the forms, the financial aid package. It's, you need to have some computer sophistication just to get through it all, or at least the tools of it. So first generation law school, first generation college, I do see and feel there are unique challenges, but fortunately these challenges have been recognized and to some extent addressed by the various colleges and law schools. We've also seen a movement of support by law schools and law firms, and particularly, big law. But here's a question: can we expect big law firms or big law to make a difference to a significant number of first-generation lawyers? And I don't believe so. This infatuation with big law, it's interesting. It's a good bellwether, a good benchmark, but really, I mean, isn't it 1 out of 200, one out of 200 or 300 lawyers go to big law? What about the other 99%? What happens to them? Who's going to help them? And so we definitely need more in this movement than just expecting big law to solve all of our problems. Okay, the current thinking is that women are now well represented in law schools, as well as the starting classes of big law. And as we saw this year, we had the most diverse summer associate class ever. From past lectures, this wasn't always so true. What's also interesting is that, law is a subset of society at large. And what's interesting to me is that both law and medicine have diversity problems. And certain professions like law and medicine seem almost immune to diversity efforts. This is an article from 2017 by Beth Robinson entitled "The Importance of Diversity and Opportunity in This Current Political Climate." Well, I don't know if the climate's gotten any better since 2017, so I think these words are still very relevant. And also, there's a thought that the public suffers because of it, because only 5% of lawyers or doctors are Black. Boardrooms remain persistently lacking in diversity, and the problem doesn't stop there. In general, no well-paying industry looks like the general public for gender or race. So let me read that again. In general, no well-paying industry looks like the general public for gender or race. So in other words, well, it speaks for itself. And that's a great litmus test to see where are we in this battle. And it's interesting that it's as well in the medical profession as well. I imagine CPAs and accountants and other areas that are well paid. So I like to look at the sort of broader view of society to try to find answers, because again, what's going on in the medical profession? What can we learn from their efforts? What can we learn from other fields such as accounting to make progress? Current literature tells us progress is happening. I'm pleasantly surprised because growing up in the 70s and 80s, the problems were just so ingrained. So here's a summary of the current trends. NASDAQ supporting diversity, Florida not allowing their attorneys to get credit where the panel had a quota. It's far off. And then California finding certain diversity requirements to be a bit vague. Of course, that's at the Superior Court level. We'll see how that percolates up to the higher courts. But at least these issues are in the forefront of the news for this year. Stanford Law Review elected its first Iranian American Muslim president. This is a tangible stride in religious diversity. Also, the big law firms have raised their bar on billable diversity and inclusion hours. One large law firm is now allowed up to 125 hours per year in pre-approved D&I work to count toward billable hours and bonuses. So there seems to be more trend this year than what we saw last year. Black women lawyers are still relatively few in number, but are supported and trusted by a leadership. Big law is starting to focus on addressing Black women lawyers into their fold. and making that happen. This article by Paula Edgar, she artfully addresses the issues of firms speaking out in the Black Lives Matter movement. Also, diversity can be looked at in many different categories that I think are going to change and be expanded over time. And ageism is believed to be pervasive across industries in North America. Workers fear age-based bias may lead to job loss. There's been a survey on that. And what's also interesting is the proposal for mandatory implicit bias training has been rejected by the Texas Bar Committee. So we still have states doing interesting things that can be difficult to understand. So here's one of my favorite slides. Coca-Cola General Counsel gets tough with firms that fail to meet diversity goals. If you want to do work for Coca-Cola, they've told their outside firms they must commit to at least 30% of associate and partner time on new matters to be billed by diverse lawyers. Of that amount, at least half of the billable hours should go to Black lawyers. So here's private enterprise stepping up with no backlash. No court can stop this. And I think private enterprise is really the most effective way to go. We all read Adam Smith, Wealth of Nations, and the Invisible Hand Theorem, which is all supported because there's also articles talking about with a diverse workforce, on a legal team, you're going to get more ideas, see more issues, and get better product, just as juries in our system are often diverse. We have 12 of them. And they're going to see things that not one particular person is going to see all of. So there's an economic advantage. And I think Coca-Cola is leading the charge on that. Many large companies such as Cisco have aggressive D&I, maybe now it's called DI&E departments. So we're seeing it in the corporate world, which I think is going to be a lot more effective than big law firms doing what they can. It's good they're doing it, but to me, where the rubber is going to hit the road is corporate America requires law firms to be diverse. In a article of December 2020, there's an article called Structural Racism. Is it killing us? Now what? Here are some policy recommendations. The article looked at the bigger picture items such as housing and healthcare. And again, I agree in that looking at the bigger picture, because again, lawyers were just a product of our overall environment. And I think this 2020 article about looking at housing fits in well with this 2022 ABA movement to require counseling in loans for diverse populations, because loans for housing are important as part of the bigger picture. So I think the ABA is in the right place, requiring ABA accredited law schools to deal with loan counseling and cross-cultural competency. Is mental health a point of diversity? I would agree. And there is a movement to reduce workplace stigma for those with mental health challenges. And when addressing law school mental health stigma, law schools should consider having wellness diversity representative integrated into their specific program. So here's some great articles about dealing with mental challenges and not making that an impediment toward moving forward. There's a lot of great organizations who work on that. I like this term belongingness. It's something that we don't see very often. And what it means is we all want to belong to a group, but our human nature can make us prejudge those who are not in our perceived group. So belongingness seems to be one of the current trends, but studies of belongingness go back many, many years. And We're going to talk about maybe the cave experiment later if we have time. So one of the best articles to date are 14 ways to discuss diversity in your law firm. And I'd recommend that these 14 ways are also applicable to discussing diversity in your local county bar association. And so I have some quotes here taken directly from the story of this ABA journal. The link is right there. The do's of discussing diversity. Do make it known that you want to be corrected if you say something potentially offensive. That makes sense. So in other words, you're getting ahead of the issue. You aren't finding it taboo, and it's good to take the lead. I mean, success favors the bold. So it's good to be bold and say, hey, if I say something offensive, please let me know right away. Do ask direct questions than rather awkwardly skirting the subject. Okay. Do ask what you can do to promote diversity within the firm. And again, I would say within any organization that you're in. Do promote open discussions of diversity. Again, favor fortunes the bold. Do be forgiving of politically incorrect statements by others if the person has good intentions and is trying to learn. So a lot of us are products of our vocabulary learned in the 70s and 80s, which is far from enlightened by today's standards. And so it's important to be understanding and correcting of such things that that don't sound well to today's ears. Do ensure the diverse employee has meaningful involvement in work if you advertise or pitch their diversity to obtain the work. So this dovetails into the Coca-Cola requirements of certain amounts of billable hours need to go to the diverse pool of associates. It's sort of putting your money where your mouth is. This sort of goes into having integrity. Also, do let others know when they have offended someone or you. This is good about speaking up because people can't read your mind, and it's always best to get in front of issues and just speak up and say, hey, I found that offensive. You deal with it. It's never that hard once you bring it up, and then you move on with your busy billable day. The don'ts of discussing diversity. Do not be offended if a diverse person would rather not answer your questions or engage in a discussion. We all have the right to remain silent. And also, there's an issue of do the discussions, do the quotas perpetuate stereotypes, like the one judge said above in the earlier slide. I mean, who knows? That's something we're not going to solve ever. But if someone has that view, they don't want to talk about it, that is fine. The other don't is do not make disparaging comments about any race, gender, or sexual orientation, because you never know the background of your audience or their family. That makes sense. You just don't want to say bad things about anybody or disparage any other category, such as mental health, physical mobility. I mean, the list just goes on. Speech impediments, anything at all. You just want to deal with people as people. Also, here's a good one. Do not start a conversation about diversity with the phrase, so what are you? I mean, that asks people to sort of put themselves in sort of a pigeonhole. And of course, there are an infinite number of categories that can be considered diversity categories. So how do you just pick one or two when there's so many to choose from? So it's very limiting and not an enlightened way to start a conversation. Do not let it slide if attorneys in your office roll their eyes or belittle discussions of diversity. It is particularly important that leadership shut down this behavior. So even in your private moments with your closest buddies, there's just no need to say bad things. I think we are a product of what we practice. We're a product of what we say. And so every Every word we utter makes a difference. Do not force diverse attorneys to use their diversity for your convenience if it makes them uncomfortable. I think that one speaks for itself. Do not bring up someone else's diversity during introduction to a new person, potential client. It will be transparent to everyone why you are bringing it up. I guess that needs to be said, but it's good that we have these lists here people can look at and just sort of fine tune their cultural competency. Do not tell people who are diverse, but do not look diverse, that they don't count. That's interesting. Yeah, I think everybody counts. This sort of goes, it's too bad we have to talk about people who don't count. I'm sorry that has to be there in there, but it's an interesting article. Okay, covering the movement. The literature on achieving diversity in the law goes back for decades. Up until a couple of years ago, there was no great progress in the field using the current metrics. No silver bullet systems were known. And this could be a nationwide or worldwide challenge, reaching all professions, again, reaching into society at large. So what's been happening in with the states, the state bars? Okay, so New York previously had a diversity and inclusion office, and Illinois and New Jersey have more recently joined the ranks. And I think California also has a D&I requirement for CLE as well. And from the New York State Bar website, diversity in programs must relate to the practice of law and may include, among other things, implicit and explicit bias, equal access to justice, which gets into the equity rubric, serving a diverse population, diversity and inclusion in initiatives in the legal profession, and sensitivity to cultural and other differences when interacting with members of the public, judges, jurors, litigants, attorneys, and court personnel. So to me, what this means is, be mindful at all times with everyone. It's a simple theory that makes sense. And it's well articulated here on the New York State Bar website. Categories of diversity appear at this time in New York to include race, ethnicity, national origin, gender, sexual orientation, gender identity, religion, age, or disability. And disability is an interesting concept. And from Matt White, our past president here of our Marin County Bar Association, this is something I think about. I thank him every time I see him, that he believes in a broader definition of diversity, of anything that causes difficulty or is an impediment in practicing law or interacting with others. So I think that's a great definition of something that can be a disability, and disabilities, I think, fall into categories of diversity. So we can have such things as age, lack of computer skills, mobility challenges. The list is endless. So it's good we look at people as a whole, age, other factors, and again, look at society at large, figuring out what's going on in our small sliver of the legal profession. Okay. Mentoring and networking systems seem to be a great answer. Unfortunately, I'm about out of time, so to quickly summarize, networking groups, small groups, having mentoring programs, and I find small groups seem to work the best. Our Marin County Bar Association, we have a wonderful diversity section that has informal mixers. Everyone goes, and it's really good for inclusion. for people to meet on sort of a smaller, more humane and scale where you get the one-on-one conversations. All right, well, unfortunately, my hour is up. My contact information is at the last slide here. My website is nielsenpatents.com. I'm on LinkedIn. And if you Google Marin County Bar, Marin County Patent Lawyer, my information comes up. I look forward to your emails and letters on ways that I can improve this presentation, any trends that you see, any interesting subjects for next year. Thank you for listening, and it's always a pleasure working with this organization and presenting this very interesting subject.